We are going to kick off again now with Dr. Robert Harrison, who is going to share his wisdom and insight with us. So thank you. I hope the break was good and you got your refreshments. So the next sort of hour or so is going to be dedicated to Robert and Gronya, and then we will head into lunch. No, did someone say? You don't want lunch, or? And then this afternoon, as I said earlier, we will move into the roundtable discussion. So hopefully you've managed to sign yourself up for one. If not, a quick last plug for doing that. But Robert, I'm going to hand over to you.
Yep, thanks very much indeed. It's great to be here today, and on the roundtables I'm supposed to advertise, I'm also doing a roundtable this afternoon. So if anyone wants to find out a little bit more about data privacy, artificial intelligence, do feel free to sign up to that table if there are still places there. So where are we today? Well, I prepared this set of slides 2 weeks ago. Somebody said they were listening to Radio 4, was it this morning, and there was a whole lot of stuff on artificial intelligence. So von der Leyen, the European Commission president today, is supposed to be making a big announcement about simplifying the rules and regulations in the EU's Artificial Intelligence Act. So hopefully this evening my talk will still be relevant, but what we're going to certainly be talking about is basically the broad guidelines for the Artificial Intelligence Act that you actually have. That's a little bit about me. I've actually got a physics background initially to start off with, and then moved into law when I was working for IBM many years ago. I won't go through this case study. Some of you, we were talking about it. It's actually based on Proctorio, which I think some of you know about it. And it was a bit of a question, and you can look at discussions about how legal that actually might be in it. But Gronya's going to be talking a lot more about what they're doing within RM later on. So I think we'll just skip that one and just move through to actually understanding what the European AI Act is. And basically, it is something that applies in the European Union. It applies also in Liechtenstein, Norway, Iceland, and will be applied in the near future into Switzerland. It does not apply to the United Kingdom. The Act was actually passed after Brexit, so there is no direct applicability of this Act. But, and the big but that you have to bear in mind here, is that even as a British company selling services based on artificial intelligence into anybody in the European Union, you will need to have to be aware of this, how it is actually going to work, because otherwise your systems will not be valid in the European Union. What it is really trying to do is basically create what we've already talked about today, a human-centered, human-in-the-loop was what Tom called it. So something is on my slide later on. System which is supposed to be trustworthy and is also supposed to be explainable. And the way the Europeans have done it, they've done it in a way to get categories based on risk assessment. Why do we need to do it? Why don't, we've all talked today about AI technologies in our daily business, but there's massive potential obviously for misuse and unintended harm. And basically we need to balance the opportunities for innovation with our ethical responsibilities, stuff we've already talked about later today. So, the main aim of the Act was to ensure that AI systems respect what they call the European fundamental rights and values. And yes, these are the EU stuff. These are values that were created whilst the UK was still a member of the European Union, and they are certainly values that we would recognise in the UK. It's basically designed to avoid market fragmentation. Various countries throughout Europe were starting to think about how they should regulate artificial intelligence. And it would have been crazy, for example, if Germany had regulated in one way and Austria, also a German-speaking country, had regulated in something else. So this is one of the reasons why they wanted to do it. And as I said, it applies to everybody who is providing services into the European Union. Just like GDPR applies to any American company that is collecting data in the European Union, this will also apply to American companies, British companies, Australian companies, even Chinese companies. I don't want to know how many of you have downloaded DeepSeek, but if you downloaded DeepSeek, you're contravening, for example, UK GDPR rules. But we'll leave that one aside. So, where are we at today on this system? Well, it's basically divided into 4 different categories. Category 1, unacceptable risk, app systems which are prohibited because they do so significant harm. Those regulations came into force last Sunday, the 1st of February. So if you have a system prohibited because it could cause significant harm, that is now forbidden in the European Union. You're forbidden to provide any of those services into the European Union. I don't think that applies to any systems that we're hearing about today. However, high-risk systems. These are systems which require strict regulatory oversight. And I've mentioned here AI medical devices and autonomous vehicles. That is a rule that is going to come into place in mid-2026, and this is where we start getting into assessment systems here, because they will be considered to be either high risk or limited risk, and I'll come to that in a moment. Because limited risk, subject to transparency requirements, AI-generated content or chatbots. And then, of course, there's basically very, very simple minimal risk systems. We've talked about spam filters, for example, with AI applications. That is not going to be a problem at all. So these will not have much regulation or hardly any regulation at all. So what is prohibited? Well, this is a horrible slide. I can't even read it here without my glasses. So I don't expect you to basically to do it. But let's look on the left-hand side. Compromised privacy. That is where DeepSeek probably fails, to be absolutely honest with you. Prohibited anything related to human dignity, human autonomy is really important, and deep fakes. Those are the areas that we need to think about. The one area that I would actually highlight here in this room is section 4, which is called social scoring. Now that doesn't mean social scoring in the sense of exam marking. That basically means the social scoring, which is based on evaluating or classifying individuals or groups based on their social behavior. That is something that is absolutely forbidden going to be forbidden in the European Union. It is almost certainly forbidden in the United Kingdom anyway under existing laws, and of course applies probably to China, which some of you know have got similar systems for social scoring. But I do want to point that one out because people have actually asked me when they look at social scoring and they say, that could be exam assessments or something like that. That is clearly not going to be part of this absolute forbidden. And this all started up to the 1st of February, a couple of days ago. Now, the European Union promised loads and loads of guidelines on that. Well, they didn't arrive. They arrived, I think, Tuesday of this week. 135 pages of guidelines. To be frank with you, I haven't even read them myself. I did put them into Notebook LM and I got a nice little summary out of it, but I decided that we're not even going to try and look at them today, because the most important thing is this, the high-risk AI practices. And the most important thing there that you can see is this: educational and vocational training is considered to be a high-risk practice. Now, those use cases are going to be governed from the 1st of August 2027. Okay, so I've got 2.5 years or 2.25 years before I need to think about putting those into practice. Yes, that is certainly true, but if you don't start designing your systems today, then you will actually have a massive problem if you're going to have to redesign them the 1st of August. Many of you have obviously would probably have remembered how when GDPR was introduced, how people had to do back design systems to make them GDPR compatible. Most of us ended up responding to numerous emails saying, sorry, do you want to continue on this distribution list because we haven't recorded your permission to do so? That, if we don't get it right now, is going to cause an immense amount of problems in the future in order to do it. Other issues that is going to, so the 1st of August 2026, I don't think we need to worry too much in this room generally about it. There's some training issues that, safety components of a product, some of those issues you might have to be thinking about in your health and safety sort of issues that you'll need to be thinking about, required to undergo a conformity assessment. But the use cases, the general use cases, particularly educational cases, is something that won't come into play until 2.25 years. There are other issues, the biometric identification system. How do you recognize a person who's doing an examination for you online? I know. So some of my colleagues are currently doing some patent attorney examinations. They're using a remote system which uses biometric identification to identify who is actually taking the examination as well. Things like employment, anybody who's using AI systems for employment, again, that is going to be governed in the future by the EU AI Act, and issues such as access and enjoyment of essential public and private services, law enforcement, migration, administration of justice and democratic processes. Those are the areas I think that are going to be massively impacted by the EU AI Act, and that's something that we're going to have to consider. So let's talk more about the high-risk systems. So we've already talked about how important it is to think about the risk that is involved in it. You are going to need to introduce in your AI system that you'll do for the high-risk AI system to make certain you have a risk and quality management procedures put in place, data governance, transparency, accuracy as they call it, the robustness. We've talked about biasness in data sets. That is going to have to be an issue that you're going to need to discuss in the future. You're going to have to be able to provide, if necessary, technical documentation to actually demonstrate compliance. Now, that doesn't mean to say that you're going to have to produce all of your data sets and print them out on paper. You're going to have to explain where you get your data sets from. You're going to have to explain how you've made certain that you've removed bias in your data sets, and you're going to have to keep fairly detailed records about it. More importantly, is there's going to have to be quite clear instructions for the so-called downstream deployers. So if you've got a platform running in the United Kingdom, which is being used downstream by people in the European Union, you are going to have to provide those users fairly detailed instructions on how to use the platform to make certain that it works with what you're going on. And there are mandatory risk assessments and continuous monitoring that's going on. Now, Gráinne is going to talk a lot more about what they're doing within the RM platform here. We had a little bit of a discussion earlier on, and I'm sure maybe she'll be able to reflect what we talked about at that stage. The other thing that we do need to bear in mind is that users must be informed. You cannot use an AI system without telling the users that they are using an AI system. We all know some of these chatbots that appear on British Airways chatbot or something like that is almost certainly an AI system. I think they now tell you it's an AI system. They weren't telling you it was an AI system. Or some of the other companies, they're not telling you that they're using AI systems. That's okay at present. Whether it's a good thing or not, I won't get into now. But actually from mid-2027, you are going to have to think about it. Now, where are we here? Why did the European Union actually decide to go down this route very quickly, very early? Basically, it wanted to try and establish a gold standard for regulation of artificial intelligence, just like it has effectively done it with the GDPR Act, where countries around the world are adopting many of the provisions that we find in the GDPR Act. They've revised them a little bit. Experience shows that maybe it's not as gold standard, not as good as it could have been. There are things that need to be improved, and I'm certain that's going to happen with the EU AI Act as well. We've also seen massive pushback, particularly from the new administration in the United States, on whether it is over-regulated or not. One of the reasons probably why the UK chose not to sign the declaration yesterday in Paris, whereas everybody else, apart from the US, signed it, including countries with similar legal systems like Australia, Canada, I think New Zealand also signed it. All of the European Union signed it as well, because they were worried that this may be too much governance there. And I must say, when we have 135 pages of guidelines to follow, that probably is overkill. What I've put down there, potential for other regions, for example, the United States and China, to copy these regulations. Well, I think we quite clearly saw yesterday that the United States is not going to copy these. But what we've also seen is that US companies are going to have to obey EU regulations there. Several large global American companies have already been fined by the Irish data protection authorities for because they're not following GDPR rules, and that is going to continue. And Meta is still, for example, moderating conversations on Facebook in accordance with the regulations in Europe, although Mark Zuckerberg has announced that they're not doing it any longer in the United States. And what's going to happen with Twitter and their lack of moderation? Well, there's lots of challenges on that. So, those basically are the implications of the EU AI Act at a very broad level. As I say, we need to start thinking about it now. Providers, platform providers such as RM and anybody else is going to need to be thinking about it. Anybody else who's developing examinations, developing training systems, is all that they want to deploy within the European Union certainly needs to be thinking as well how to go about doing it, what are the Europeans actually going to want to do it. And it's probable, and I would say it's almost certain, that if you want to deploy systems anywhere in the world, other countries are going to copy the European regulations, lock, stock and barrel. So, very broad overview today. I'm sorry I can't go into much more depth in the time that was allotted to me, but I think
it's good.
I hope you've been able to...
You've still got plenty of time.
I've still got plenty of time, so we have some... I planned it for 15 minutes, and we've still got plenty of time for questions, and we can deal with any other issues that we actually want to have. Yes.
Microphone.
Thank you. I know you talked about the EU AI Act and you talked about United States as a federal government, but there are states, aren't there, that are potentially taking on very similar policies, and that's an area to navigate as well. Am I correct?
Yes, you're absolutely right. So, and I think the most advanced is California on that, which is basically, I won't say they've taken the EU regulations one-to-one. They haven't taken the EU regulations. They've not passed the law. I believe it's going through the Californian Parliament or something. I can't remember what they actually call it down there in Sacramento. But they are very much looking at adopting very, very similar procedures. They have, I think, adopted similar procedures with like the GDPR. And that's fine for Californian residents, for example, but because it's been the moment to go outside of California, then they don't have that responsibility. There's about, I think it's 20 other states in the United States that are looking at the EU as inspiration for regulation of artificial intelligence. Back in the UK, actually, probably worthwhile dealing with. 2-3 weeks ago, the government published a consultation document, which was actually talking about how do we want to do it in the UK for regulation of the EU of artificial intelligence. And it specifically rejected certain proposals from the EU Artificial Intelligence Act. But there is almost certainly going to be new regulations coming into play at sort of within the next year within the UK. They will probably be a little bit more liberal than what we have in the EU, but that doesn't mean, as I keep on coming back to you, as a British company, you will, and want to export, use these services in the European Union, you have to simply obey EU regulation. It's a point I've actually made in a submission to the government as well, saying, keep as closely as possible together, because otherwise you will have massive issues, or British companies will have massive issues if they don't do it.
How is AI defined in that? Is it like captive testing? Or
well, I can't remember exact wording, to be absolutely honest with you, but it goes. There was a massive discussion on what should be the definition, and I can't quote it off the top of my head, to be absolutely honest with you, but we can follow up on that if I'm honest. It goes beyond very much beyond what you would generally think as being AI. So it's a pretty broad definition here, and it includes tools that are probably more traditional computer systems than anything else, to be absolutely frank with you. So some of the older systems that have to also look to see whether they might fall under some of the provisions of the artificial intelligence. There is no sort of grandfather clause along the lines of, well, I've been using it for 10 years and so I can still continue to use it. That certainly does not exist. It's one of the reasons why there's this transition period of 2.5 years before the systems are introduced, so that if necessary you can adapt your older systems to the requirements. I'm sorry, I probably could have put the definition, but I can look it up and can tell you at lunchtime if you want, or send you the link. Yeah.
Any other questions? Yeah. Two. You go for it. Oh,
Thank you. Sarah Corcoran from ACCA. One of the big topics of conversation at last year's ATP, the big assessment conference in the States, was that whereas Europe's coming at this very much from a risk perspective, in the States, I think probably at federal level mainly, the focus was more on the whole copyright issue. And I think, Gráinne, you were saying earlier, do not put your IP out there or publish your IP, which sounds like really good advice. Is Europe also coming at it from the sort of who owns copyright? Because that seems like a huge...
It's a huge one, and I decided not to try and tackle that as well during my main presentation. But you're absolutely right. So the challenge is that, so there are two ways of thinking about this. The US has this concept of fair use of copyright, has this concept where, you know, slight quotations can be used, can be cited, for example, as long as it's fair use. So you can't reproduce a book, copy a book one-to-one. I think it's about 10% you can copy, but not the complete book or something like that. And it's a very flexible term. And the AI companies in the United States would argue that they have read in the copyrighted material, they've trained their systems on the copyrighted material, but they're no longer using the copyrighted material, and that is fair use. Now, publishers, authors are not very happy about that. And there's a couple of cases, well, there's about 20 or 30 cases running, but there's a great case which it comes, so we know that the New York Times was copied, everything from the New York Times was copied. And somebody used in ChatGPT a prompt which said, write an article about this in the style of a particular journalist. And what happened on that is basically ChatGPT more or less reproduced the complete content of an article on which ChatGPT had been trained in. Not surprisingly, it has to be said. Now, it didn't copy the article, but because of all its logic that was going on inside, it was actually able to reproduce this article. And so New York Times is suing OpenAI, the owners of it, for copyright infringement. That case has not yet been decided. So we have no idea what's going on with that. The UK and the European laws are slightly different. And there's what's called the text and data mining, which says that you are allowed to do certain amounts of text and data mining for non-commercial purposes. If you want to do it, and you can also opt out from allowing people to use your text and data mining. And the way you opt out is slightly challenging, to put it mildly. We won't go into that. But if any techies will know what robots.txt is, that's the way you do it. Now, there is a very interesting discussion. There's a German case that's just gone through, which is an image database. And it was produced by a non-profit company in Germany, who were then accused of copyright infringement. And the German court decided that there was no copyright infringement because it was produced by a non-profit company. And the conditions of use said that it could only be used for non-commercial purposes. So it's designed for research purposes. And so the court case was dismissed. However, if you talk to most Gen AI companies, they will know they actually have used that database for their commercial purposes. So that's an ongoing situation. So what we're seeing slightly different rules here, and there is this massive tension between the creative people who've created this stuff and the tech nerds, if we want to put it like that, who actually want to use it. And it's not resolved. And the AI Act doesn't resolve it, and we're going to see lots more court cases about that. But to go back to Gráinne, for example, be very careful.
Court cases about
Be
Gráinne?
very careful. Be very careful what you put up on the internet these days, because it will be used for training. And I mean, you know, we've got some people from the OUP here, for example, and presumably other textbook publishers around here who probably realise, you know, the horse has bolted, and now we're trying to, you know, stop everything. So it's a long answer, and there's no clear answer. Yes, and it is, and there's massive discussions on this. You can see why I didn't put that on my slides as well.
Hi. How effectively do you think the EU will or can enforce these regulations? I mean, are the skills and knowledge there?
That's also a really good question. So they've set up a European AI office. They're having challenges staffing the European AI office. Though EU salaries are not bad, tax-free salaries are not bad, it's still finding the people who actually have the knowledge and the skills to be able to assess a lot of what's going on. I think what is going to happen, like we're seeing with GDPR, there will be isolated court cases, high-value court cases around the place, probably with individuals bringing the court to actions. There's a guy called Max Schrems, some of you may know, who's a data privacy activist who's brought several cases against Facebook over the years. And I think a lot of it is going to be private citizens, probably funded by various companies, various organizations who actually bring those actions and will actually test the law as it goes on. And it has to be said, they don't always win some of those. The guys with the the image database thought that they had a clear-cut case. They would, as owners of this database, they would win the case, but the court said no, that you didn't win that case.
One more question then, Mr. Matt Glanville.
Suppose we were doing artificial intelligence marking.
Yes.
Would a student be able to say, I wish you to mark my work, but I don't wish you to use AI to do it?
That's a very good question. Yes, the student would be able to say that, but I think you would then be able to say, well, I'm sorry, we can't write your work. So that I think, but you have to tell the student, that is compulsory that you tell the student their work is going to be marked by AI. But as I know Scorn is going to say, that we need to keep this human in the loop. And we really go back to what Tom has said, the whole of the EU AI Act is governed on the premise that we are going to keep humans in the loop at all times. And that, I think, is one of the major differences between the approach that the United States is actually going to take on that. And we're seeing already that in the United States, that they feel that you don't need to have humans in the loop. And the Europeans can say, humans have got to remain there.
Thank you very much. That was really interesting. Very interesting indeed. Excellent. Thank you.